Hey everybody, it's your boy Gene Lespinas, host of Stir the Pot. This next episode is a two-part series that focuses on how the law in the U.S. was used to create a kind of second-class citizenry amongst people of color. This episode comes after the recent passing of Ruth Bader Ginsburg, a Supreme Court justice who served on the bench for 27 years. Appointed by President Bill Clinton, Ruth Bader Ginsburg, or RBG, as she's also known, was known for her fierce support of equal rights. For that, she earned the name Notorious RBG. Rest in peace, RBG. It's often said that the Supreme Court justices are the guardians of the Constitution, whose decisions have a lasting impact on society. In this episode, my guest, Peter Alverez, and I, a practicing attorney in the Boston area, discuss the color of law and how the law has historically been used to protect a caste system based on race in this country, setting up a permanent class citizen amongst communities of color. Some of the effects we still see today in 2020. We talk about how Jim Crow laws were used to set up structural racism and new forms of structural and systemic racism we see today. I hope you enjoy this two-part series with my guest, Peter Alverez. Hey, Peter, how you doing, man?
I'm good.
Thanks for joining me on this episode of Stir the Pot. The title of this particular episode is The Color of Law. And I appreciate your, you taking my invitation to come on the show and talk about these issues. Before we get started, I just want the viewers to get a sense of your background. I know that you are, passionate about civil rights, social issues, and you're passionate about the law. And so before we get started, I want to talk about your background, some of your credentials, and frankly, where did your passion come for social issues and social justice?
Yeah, so just some background. I'm Boston boy, born and raised. We went to high school together, so Madison Park in Roxbury. And I think for me, a little bit more background, went to Boston College afterwards. I actually taught in Boston schools after that for 5 years. And then I went to BU Law, and now I'm a practicing corporate attorney, do mergers and acquisitions. At the same time, I also do kind of some pro bono work, and I'm on the board of a couple nonprofits, and have served in other nonprofits and that relate to education, criminal justice, community engagement. Right now in particular, I chair one called Union Capital Boston, which rewards community engagement. So that's kind of, where the passion comes from for me is just kind of growing up. I grew up in the 90s in Boston. I grew up in the Uplands Corner area of Dorchester, seeing a lot of, violence, crime, but also things that were unfair throughout life. I've been subject to unbridled police discretion. I've been subject to a no-knock warrant at a really young age. My dad got locked up when I was in middle school on a mandatory minimum. So kind of the laws intersected in my life. And then when I was a teacher, I saw just kind of how the law, from special education law and discipline and immigration law and everything, like, family law, to how it all intersects, how it's all very interrelated. And I think, to kind of go through that entire experience and not be passionate about this, because I feel like when you're raised within it and then you learn to understand it, there's no way you can just kind of turn your back on it. When I swear an oath to the Constitution of the United States, I think about how, for so many people, some of those rights, privileges, and protections that being an American, being a citizen afford you are abrogated. You don't get the whole bundle of rights that you should be getting. And so my work and what I, kind of do in addition to practicing law, I like to write. I like to, kind of take the helm on a couple of nonprofits. I like to do things like what I'm doing with you now, to kind of just inform the community and inform folks about kind of where we are and where everything comes from in terms of, that feeling of not having due process, not having the same rights as others, even though you may be a citizen and you may be, born and raised in the United States, that feeling that like things just aren't the same for you, that where did that come from? And is it all in your head? And I can answer right now, no, it's not. So it's basically that question that, I've struggled and looked at and wanted answers to. And I feel like it's important to kind of keep digging there. And that's where the passion for kind of doing social justice and kind of youth work and community work, throughout.
Awesome, man. I think that is, I think it's a great reason to be serious about social justice, to be wanting to inform others. One of the reasons why I started this podcast was to discuss issues that I don't see being discussed broadly in the mainstream. And so, I sort of share that sentiment when it comes to why it's important to have these conversations. So before we get kicked off, I actually wanted to let the viewers know that we're probably going to geek out a little bit on the law. And some of the reasons why is because it's really important to understand. In order to understand today, you have to understand history. So to frame this conversation, I actually wanted to talk about a book titled Caste by Isabel Wilkerson, who is a New York Times journalist who wrote a book that published this year. Essentially, the book Caste talks about and describes racism in the US as an aspect of the caste system. The idea that society is divided by tiers and is structured into a hierarchy or a type of pyramid with white society at the top. And so the purpose of this structure, when she gets into the book, is to control access to resources economically, politically, socially. And so really to understand racism, it's important that we develop this framework, right? This framework where we look at caste and understand what the caste system is. And understanding the caste system really gives you a stronger context to see how we got here today. And so with that framework set, I want to sort of launch into the first question. So racism and racial injustice in this country has a long history, as we will discuss, which predates the founding of the American Constitution. So slaves were brought here effectively in 1619. That's widely known. The Constitution was, we declared independence in 1775. I believe that's correct. 1775, 1776. So it was more than 100 years after the first slave stepped foot on this land that essentially racism, or the construct of racism, was brought into existence, or was constructed. So after the slaves were emancipated or freed, and after slavery was outlawed in this country, the Congress wrote the 13th and 14th Amendment. The 14th Amendment, which gave the descendants of anybody who was non-European or non-white, effectively, for all intents and purposes, this conversation, descendants of Africans born in this country, the right to citizenship. And what that meant was that the right to citizenship gave you access to the Constitution. It allowed you to have the same rights as all Americans who were considered citizens, which was the right to sue, the right to own property, like all of these different rights that you get. The right to be recognized in court. The 14th Amendment gave, what was formerly slaves and descendants of slaves citizenship in this country. But before that, the way blacks were governed was through a system called black codes, right? And so what we see in history is that for a good part of this country's history, Black people, anybody who was non-white, including Latino, Asian, weren't considered citizens. And there are cases, Supreme Court cases, of Asian Americans or Asians born in this country who basically contested their right to citizenship. We won't get too far into that, but that's just to illustrate that essentially, if you were non-white, you were not considered a citizen in this country.
Yeah.
And so with that said, a lot of the laws that were crafted and that were decided and that were ratified in this country were actually designed to protect the dominant social class. And so what I want to talk to you about, Peter, is how the law was used to protect that class in this country.
Yeah, and I like that you frame it with citizenship. And I think one of the things that's curious for a lot of folks is that we never really, until the 14th Amendment, you really didn't have this definition, this thing floating in the Constitution about like citizenship as defined as it is. And even later on, it wasn't that defined. And in reality, it was ruled like the citizenship clause in the Constitution was deemed to especially be for emancipated slaves, right? Folks that were post-emancipation. And when we talk about citizenship, you know, just a regular dictionary definition is a person who legally belongs to a country and has the rights and protections of that country. So for the United States, if you look at, you know, the website for immigration and services, citizenship and immigration services, it'll say, you know, basically, you know, freedom of expression, freedom to worship, the right to fair and prompt trial by jury, right to vote, right for federal jobs, run for office, and the freedom to pursue life, liberty, pursuit of happiness, those kinds of things, right? When you think of that, you kind of got to go back. First, immigration laws, the Naturalization Act, 1790, whiteness is an express requirement. That law keeps getting kind of changed over and over. They'll have certain waiting periods, and that's basically for naturalized citizenship. People that were not born here, how long will it take? Typically, it would at a 1 year waiting period, and then it's 3, 5 over time. But whiteness as a requirement was there. And then little by little, they would add other groups, allowing them bit by bit. And then sometimes immigration judges would have discretion. But I think it's important to kind of go through just a little bit of how citizenship and how these rights kind of came to be from kind of where our country comes from. So I think the next spot is 1848. You kind of have the Treaty of Guadalupe, and that is when the United States decides to annex parts of Mexico. And basically what they did was annex parts of Mexico, Texas, California, Arizona, all these places that had the least amount of Mexican people, right? Had, you know, more Spanish descended, but also Mexican folks, the people that were, you know, intermixed with people that native ancestry. And so when they did that in the Treaty of Guadalupe, they also said that some people there could get citizenship, but it was a lot of it was based on local jurisdiction. So the people that ended up getting citizenship, obviously, were the most white presenting of the group. And so the people that looked more, you know, Mexican, the way you would think of like a Mexican-American person, browner person, they were subject to kind of local, you know, jurisdiction where people would say, no, you don't get citizenship, even though they were supposed to be granted citizenship. That was part of the treaty. Sometimes they would, sometimes they wouldn't. So a lot of them were kind of almost stateless because the US moved the border. Now they were here and they almost became subjects because if they couldn't get citizenship, now they're here. And now what are they? Undocumented people. So we move through there. And then we think about 1856, that's the Dred Scott decision. And the Dred Scott decision talks about personhood and basically like who is, you know, basically a slave, someone, an enslaved person that was of African descent sued for their freedom. And they said, I'm a person. You cannot own me. You can't, you know, I'm not property. And Chief Justice Taney, like this is like one I like to quote because it seems so relevant today. The Supreme Court proclaimed Black people and non-whites generally, to give that ability that they had personhood within the United States, which would mean rights, because at that point, the Constitution really didn't state like only citizens have these rights. It was basically, this is what the United States is about, right? It didn't say citizen, it would say, man, freedom, people to be free from this and that. So what Chief Justice Taney says is to do so, to grant personhood would exempt them, Black Americans, from the operation of special laws and from police regulations which they consider necessary for their own safety, and inevitably producing discontent, content, and insubordination among them, and endangering the peace and the safety of the state. So basically, for your own good, you have to remain as proper. That's literally what a Supreme Court justice said. And that's basically where they're trying to knock down kind of like, I'm suing for my freedom. And I think it's just, to not give Black people within the United States, constitutionally protected personhood rights, like being a person was, when you think about it, that wasn't more than that was less than 2 centuries ago. I mean, that was 86. That wasn't too far back. And when you think of go where they pleased at every hour of the day or night without molestation, unless they committed some violation of law in which a white man would be punished. If you think of that ideology, right, you can't let Black people and other non-whites walk around and have the same freedom as a white man and only be punished the way a white man would be punished. Well, over time, right, when we go through time, it ends up being baked in without it being written in law, right? It doesn't necessarily have to be written in order for the applicability and enforcement of laws only or predominantly against people of color, especially Black Americans, became more commonplace. And I think from there, from Dred Scott, you have 1865, Civil War is ending. 1866, you get the Citizenship Clause and the Civil Rights Act of 1866. And then 1868, you get the 14th Amendment, which has a Citizenship Clause in it. And then you get 1896. You get Yick Woo. Yick Woo, which actually says, okay, like sometimes this was actually a favorable decision, right? Like for people of color, but it expressly was narrowly tailored that it applied to this one circumstance where Asian family was being discriminated against, Asian people were being discriminated against specifically. And so the Supreme Court said you couldn't specifically do that, right? And so in 1896, the same year, it was pretty, active year, Plessy v. Ferguson comes out. Yeah. And that is what kind of sets up separate but equal that doesn't get really struck down until Brown v. Board of Education. After Plessy v. Ferguson, where it's basically, using the train cars and whether or not separate cars are fine, the Supreme Court rules, as long as they're separate, they separate but equals okay. You don't have to commingle. And white people are restricted just the same way Black people are. So trying to find loopholes on how we can keep these constitutional ideals that we have enshrined in the Constitution and in the 14th Amendment, but also abrogating the rights for some, but acting like you're not, saying, white people could go. And in reality, right, do you think a white person would have had enforcement against them? A white man would have had enforcement against him if he would have went into a black cart? Probably not, when it goes inverse like that. But the way that it's framed is that the white people are prohibited from doing that too. So,
So I want to go backwards a little bit because I think the Plessy versus Ferguson case was really, really critical. And there's some details in there that I want to make sure that we capture, which is Homer Plessy, which was a passenger on a train car in Louisiana, basically was arrested for being a black person or having black blood coursing through his veins.
1/8.
Yeah, 1/8. It was very, very
less.
minimal amount of blackness. But in any event, he was arrested and taken off the train in charge at the time when segregation laws in Louisiana were active, right? There were separate sections in the train where white people and black people could ride, and he decided, well, he should be able to ride in the white train, but that was challenged, and so he basically took it to court, and it went all the way up to the Supreme Court, and what they decided was that essentially the argument was, well, my 14th Amendment, I'm a citizen, and that right should I should have protections under the 14th Amendment. And I'm not going to go into legal jargon, but essentially the court decided that they established separate but equal, which means that you do get protections under the 14th Amendment, except you have to be separate from the rest of the white race.
Yeah,
right.
And it kind of sets up the second-class citizenship
correct
evaluation. If you notice in these, there's a pattern of the pendulum swinging, right? You have, the Civil War, abolition of slavery, and then Civil Rights Act, and then you go, in the 1800s, and then you go back, and the pendulum keeps swinging back and forth, and I think you keep seeing that, right? So I think after you get 1898, a couple years after, you get Wong Kim Ark decision, which is about citizenship of someone who was born to parents that were residents in the U.S., right? But they were Asian, and basically this is the birthright citizenship question, and that's the first time it comes out, and it's like, yeah, you have birthright citizenship. And then a Nationality Act in 1952 actually expressly prohibited racial and gender discrimination for naturalization. So when you wanted to go and become a citizen, that was the first time that it was actually prohibited. There was all these cases where people from the Middle East, Asia, Africa are trying to kind of persuade an immigration judge that they meet the whiteness requirement for citizenship, which was actually in there until 1952. People kept adding different countries, like, oh, okay, we'll add this country, you can apply for citizenship. They would do it on a country by country basis, but whiteness was still kind of there until 1952, where it's like, you can't expressly, you cannot discriminate based on race for citizenship. So when you think about the way we have created citizenship in itself, right, to become a naturalized citizen for so long where whiteness was a requirement, and then you have all those cases of separate but equal, and you have all these instances, you start to get a framework of who is the first class citizen, who is the citizen that is the most deserving of due process, who is the citizen that is the most deserving of all rights, who's the citizen that should be free to express, who is the citizen that should be free to own and carry and open carry a weapon, a gun, AR-15, who are the citizens that can, petition the government, who are the citizens that can vote and have free and full voting rights, right? When you start to think about that, you start to see how that framework has kind of keeps evolving, right? So then in the 1960s, you get the Civil Rights Act, and you get expanded voting rights and protections of voting. You get, Brown v. Board, you start integrating schools, and then you end up with de facto kind of, discrimination. People move from neighborhoods, resources go away, and now you're getting abandoned parts of cities and towns that, they're not being responsive. Elected officials or state officials aren't being responsive to the needs of the people that are, subject to second-class citizenship. And they're not able to kind of vote. You still had people creating barriers to voting, and that still exists to this day. Right? It's still continuing to this day. So you pass the Civil Rights Act. Then in the 1970s, 1980s, you get all of these waves, and in the 1990s of these criminal, kind of state, national, crim law, which usually criminal laws, before, let's say 90 years ago, criminal law was very state by state. You didn't have these big criminal law like the feds, like the way you have it now, right? Where you can get locked up by the feds. You could, but there was just like a few enumerated things you could get locked up for. Now you kind of have a situation where, you know, drugs was one of the main things. Bootlegging drugs, those are, you know, kind of things that became federal crimes that you could get locked up for. You could get locked up for them, you know, in the states, but also federally. You got these mandatory minimums. You got, you know, more like kind of abilities to go into places. And then in addition to that, you gave more discretion to law enforcement to actually be able to stop, frisk, go into homes, do no-knock warrants. All of these things went through the Supreme Court after that. After the
right. You know, we're getting into a later part of the discussion.
Yeah.
That I kind of want to save.
Yeah. So, but that's just the framework there. And if you think about what's going on now and how it all affects everything, I'll give you one prime example, and then we can move to the next. But one prime example that just came down was felon reenfranchisement. Formerly incarcerated folks getting reenfranchised in Florida was done via constitutional amendment in Florida. It passed overwhelmingly in 2018. So pendulum swung that way. What did the legislature do? That group of people ended up being 1.4 million people that were disenfranchised. Ended up being 20% of Black adults were disenfranchised, and 10% of the total Florida population were disenfranchised. So Florida being what it is, it's the quintessential swing state. It's a state that, like, Democrats and Republicans can each win, and they lose by 1 point each way. The very Republican and very gerrymandered legislature there and the Republican governor passed a law saying they had to complete their sentence, and that means pay all fees and fines. Now, there was no system set up for fees and fines, like where to know how much you owe, anything like that. So now people are left and they're trying to register, but they can't because they don't know if they have a fine, and no one knows how to, or if they do have a fine, where to pay it to. So there's all these extra hurdles now for these people that are disproportionately people of color that are trying to vote. And even, you know, when LeBron, I don't know who it was, I want to say LeBron James, but somebody went and they'll pay it. It becomes difficult because it's hard to track what they owe where. And so that's just another prime example. And there's a federal court basically enshrined that. They said, yeah, that was fine. Like paying it, that to me, that sounds like a poll tax, right? But, you know, the pendulum swinging. And there's always going to be a reaction to enfranchisement, to the additional rights of someone getting additional rights. Because people don't think we grow the pie. People think, you know, giving someone else rights takes away theirs, if you've noticed.
Yeah, no, I absolutely. No, I agree. I think that's often the conversation that I hear in the mainstream, which is a sort of talking past each other, where, you know, one group is talking about, hey, I just want my rights, and the other group looks at, you know, the request, the contesting of, you know, not getting certain rights they feel entitled to as a threat to you know, their personhood, right? A threat to their rights as citizens. And as you said, it's not even one of those things where the person who's petitioning their rights wants to take away anybody's rights. You know, I just want to enjoy the same rights you're enjoying. But it's a sort of talking past each other. And, you know, there are many reasons for it. But I think you know, this is a good example that you make. You know, just to kind of go backwards and from my understanding and the audience's understanding, to summarize, which is, you know, the question, which is how was the law used to protect the dominant society in this country? And we see that citizenship was a tool, right? You know, it was one of the tools that were used, sort of a gateway, right? And you would deny access to the gateway to a segment or group of people who you didn't want to be able to participate, and only bring in those folks who you felt met the standard. In the book Caste, what Isabella Wilkerson says, which I thought was interesting, I knew the concept, but the way she described it was pretty interesting. She said that over the years, whiteness, or the definition of whiteness, was curated. So whiteness was actually evolved over the years. And it was curated to include other groups, Europeans, or those who would pass or be considered white. It was sort of expanded to include that group. And so when there are certain Europeans who came here, like the Italians initially, were sort of looked down upon, and were looked and considered to be inferior. Over time, groups like that were actually sort of brought into the fold, right? Consolidated, because they met the definition of whiteness. And so I think that's an important concept to understand, is that the law in this country, they say, this sort of brings me into the second question.
And I would just to point out, whiteness, the way that it defined too, has always been as of exclusion. So if you look at Plessy v. Ferguson, Homer Plessy was 1/8 or less black, right? So but he was still excluded, where whiteness was based on like what you are not. Like, this isn't whiteness. Whereas for everything else, you could say you're black, you're 1/16th, you're black, you are 1/32nd Native American, you're Native American. Whiteness was always based on exclusion, because through exclusion, you reserved a certain amount of rights for the people to have kind of the apex of citizenship, first class citizenship rights.
So, it's interesting because it leads, so your statement actually naturally leads me into the second question. But before I pose the question, I actually want to, so that Plessy versus Ferguson case, in the majority opinion written by Henry Billings Brown, in the majority opinion, he states that the objective of the 14th Amendment was to undoubtedly enforce the absolute equality of the two races before the law. But the nature of things, it could not have been intended to abolish distinctions based upon color, or to enforce social or distinguish from political equality, or a commingling of the two races upon terms unsatisfactory to either. So essentially what he's saying is that, yeah, you're equal, but the 14th Amendment wasn't designed, to
force you to hang out, to force you to be socially with one another.
Exactly. And so it's, go ahead. Sorry.
No, go ahead.
Oh yeah, so essentially, when you say it wasn't designed for you to hang out socially, so what we know is that the separate but equal, even though that was the doctrine or the sort of legal way to think about to think about equality at the time, was defined to think about equality in terms of, you're a different race, but we still consider you equal. We know that whole doctrine, separate but equal, was actually intended to create a second-class citizen. And what's interesting is, in the dissenting opinion, Justice Marshall Harlan, he wrote this. So dissenting essentially meaning that he didn't vote with the rest of the justices, even though
he disagreed.
He disagreed. So everyone, this is what he writes: everyone knows that the statute in question has its origin in the purpose, not so much to exclude white people from railroad cars occupied by blacks, as to exclude colored people from coaches occupied by or assigned to white people. This thing is to accomplish was under the guise of giving equal accommodations to whites and blacks, to compel the latter to keep themselves while traveling in railroad car coaches. No one would be so wanting in candor as to assert the contrary. So essentially he's saying that we know that this was designed to create a second-class citizenship and to exclude blacks.
Mm-hmm. Yeah, and that's basically, I mean, that sums it up. It's, like I had mentioned, like, would anyone be prosecuted, or would laws be enforced against a white person that actually went into the black car? Probably not. And so that kind of gives you, if you can draw some direct parallels to today, who gets prosecuted for what, and who gets arrested for what, and who gets surveyed for what, right? Like what kinds of laws, what kinds of crimes do we, do a no-knock warrant for? We do it for, drug crimes? Yeah, a lot of times. Do we do it for, like wire fraud? Not as much. Right? Like maybe, but not as much. Do we do it when like pollutants are being thrown into like a river? Probably not. You're not going into the CEO's house at 2 a.m. without knocking, right? There are warrants that get issued in the middle of the day and someone comes into a workplace and it's like, we're going to get all the files. That's very different than a no-knock warrant in the home. And, court doctrine and everything makes the home a very special place, a more protected place. But yeah, it's about social rights. And I think when you think about it, people, it's kind of like growing that pie, right? Where you think me getting rights makes you have less rights. It's kind of the same thing. It's like, my social right to just not have you get rights. That's my right too. I don't want you to get rights. I don't want interracial marriage or, before Loving v. Virginia, like people thought they had a vested interest in saying, I don't want interracial marriage, more so than the folks that were trying to get married, wanting to be married and have that right to, life, liberty, and pursuit of happiness, equal protection under the law. Like they can marry who they love, both are citizens, they can do that, right? Like that right had to kind of supersede the right for someone to just not like it. And you see that all the time where the dominant group's kind of social right, which is not in the Constitution, just the social right. I don't like this in the atmosphere. I don't like this happening around me. So end it. I'm going to make laws about it. That's my right versus it's my life. Like this is my rights, my constitutional rights, you are sliding up against your just like social preference. And those things shouldn't, I think sometimes courts almost use them to be equal. And if you think about it, right, you think of systemic and biases that people have, because everyone's going to have them. And the courts are mostly white, they're mostly male, they're lifetime appointments. Of course, that is going to be baked into, doctrines in our jurisprudence in the United States.
Yeah, no, I think, I love the last statement you made about the law as a tool to enforce the preferences of the dominant social group, right? There's a statement, and I keep going back to these cases, the Dred Scott versus Sanford case, which was decided in 1857, in the majority opinion, Justice Roger Taney, which you referred to earlier, he says this, and this perfectly captures what you just said. United States Supreme Court Justice writes in the opinion, we think that Black people are not included and were not intended to be included under the word citizen in the Constitution, and can therefore claim none of the rights and privileges which that instrument provides and secures for the citizens of the United States. He says here, on the contrary, they, at the time of the founding of the United States, were considered to be subordinate and an inferior class of beings who had been subjugated by the dominant race, and whether emancipated or not, yet remain subject to authority. And this is one of the key statements. And had no right or privilege but such as those who held power and the government might choose to grant them. Mm-hmm. Very, very telling statement. And mind you, this was in 1857 when the dominant attitude, this opinion reflected essentially the dominant attitude.
Yeah.
The dissenting Justice McLean, he wrote this about this Dred Scott case. Deeming the argument that Black people could not be citizens seems more a matter of taste than of law. So, here you have two Supreme Court justices both sitting on sitting as presiding justices at the same time. This case was decided, and you have a very succinct statement by the dissenting justice that basically says, well, we all know that this decision reflects the preferences of the majority.
And the case wasn't even about just the case. That was more of a one-off on the case. It was about he was doing away with that argument right off rip. Like, are you citizenship? No, that doesn't even count for you because of X, Y, and Z. Now, are you granted some other additional like personhood rights as a person here in the United States? No, not that either. So like that's the interesting part about it. It was like he wanted to cover his base there with, even if, you're free and you're not enslaved, like that still doesn't mean you have citizenship.
Yes.
The rights and privileges and of citizenship.
So it said of the Supreme Court that it's really set up to act as the guardian of the Constitution. Like that's why the Supreme Court exists. Yet we see examples, as I read earlier, where justices decided cases based on something other than considerations for the Constitution. Prime example I talked about earlier, Plessy versus Ferguson. So to give you some context, when Plessy versus Ferguson was decided, essentially, that was the most deadly period in history, recorded history, for Black people being lynched. About 1,100 in that decade, Black people were lynched from 1890 to 1899. And so the Plessy versus Ferguson case, that was decided essentially to not upset the dominant social group. And in the opinions, you see that reflected. I talked about Justice Harlan, who said, that this separate but equal really is a guise. And so with that said, the question here, or before I get to the question, Plessy versus Ferguson, which established the doctrine of separate but equal, actually kicked off Jim Crow, which had a stronghold, this system of laws that's
Plessy v. Ferguson, Plessy v. Ferguson,
Plessy v. Ferguson essentially kicked off Jim Crow, right?
Yeah.
And what we see is that the country, mainly the South, adopted a system of laws known as the Jim Crow, where Black people were excluded from participating in all kinds of things, loans, the economy, politically, social accommodations, so on and so forth.
The franchise of voting.
Correct. So that question being said, knowing that the history, everybody agrees that racism, that there is a history of racism in this country, but some folks would say, not so fast. We've made a lot of progress, right? And they cite Brown versus Board of Education. They cite the 1968 Civil Rights Act, so on and so forth. The question is, the systematic racism still exists in the country today, and in what forms?